Now I think we will invite our next speaker, and we will have a speaker from UK this time, from Speechley Burkham, as an ambitious full-service law firm with over 250 lawyers headquartered in London. And the next speaker, Mr. Chris Putt, is a partner from Speechley Burkham, and he's an experienced corporate finance and mergers and acquisitions lawyer and leads natural resources group of the company. Welcome, Chris. I think you have already received the invitation to be a presenter, so all you have to do is start broadcasting and you will be online.
Everybody, I'm sorry about the technical hitch. I'm very unfamiliar with the webcam technology. A very interesting presentation from Green Environment about joint ventures and how important the joint ventures were to their development. What I'm going to do is to talk through some of the principles behind some joint ventures and hopefully turn what is a rather dry legal subject into something that is more directly applicable to you. In principle, there are three types of joint ventures, which I hope you can see on the screen. One which is based on a simple contract between the joint venture partners, one which is a formal partnership, and the other a corporate joint venture, where the two partners or three or four partners, however many, come together and establish a new company through which to carry out the new venture. So what we'll be looking at is how to choose which one is right for you. The approach we've taken is to look at the themes that everybody has to consider when setting up a joint venture, rather than to discuss this from the rather more legalistic or formalistic approach. So when people come together to carry on a new business, one of the things they will be concerned about is how to manage the risk associated with the joint venture. What I mean by that is that in principle, people come together because they need to share resources. The classic joint venture is between a financial investor and a technology company. The financial investor obviously brings the money to the technology company in order to enable the technology to develop and the business to grow. And so there are different risks associated with that. The financial investor obviously wants to see his risk in the finance reduced, and indeed to see his return enhanced. The technology company doesn't want to lose control of the technology, let alone ownership of the technology. So in every circumstance, there will be different risks that need to be addressed by the parties. If you simply establish a contract, in other words, perhaps the most common contractual joint venture is two construction companies coming together to bid for a new project. Each one agrees that if they are successful, then they will continue the joint venture in a particular way. So everything depends on the contract. You agree in the contract how you will split the risk and how you will split the reward. Often, one of the two parties will be the principal contractor and will take the lead in the negotiations with the third party. A partnership, the legal form of partnership, implies a joint and several liability. So even if it is not your fault, you will still be jointly liable with your partner and at risk if a third party takes action against you. The usual way to minimize that risk is then to use the corporate joint venture to set up a new company, and the new company is then the entity that carries out the joint venture and enters into the contracts that are required in order to pursue the joint venture. So it is the special purpose vehicle, the JV Co, which takes 100% of the risk associated with the venture. And the partners become shareholders in that joint venture company, and their risk is only to the amount of the capital that they contribute to the joint venture. I touched on management and control just a moment ago. This is the next theme. If you simply have a contract between the two of you to pursue a particular objective, the contract is all definitive. And so the contract must then determine who will control the joint venture and how the control will be shared between the two partners. So the risk associated with the contractual joint venture in this respect is that you forget something. that the contract is not complete. In a partnership, when two parties come together for a common purpose, the general implied rule of law is that you must be unanimous in your decisions. And unanimity is often not practical, and particularly as soon as you get several parties to a joint venture, it certainly becomes impractical. Perhaps between two parties who know themselves very well, understand the nature of the business that they're entering into, these questions of unanimity are less of an issue. But otherwise, it can be rather impractical for larger joint ventures. As soon as you get into a corporate environment, the general rule is majority rule. So if you have a majority of the voting rights, you will be able to decide how the joint venture operates. This then begs the question, if you have a 50-50 joint venture, that takes you back to the unanimity problem that we've just been discussing. And your joint venture documents would then have to address what happens if you can't agree. There are also, as a matter of corporate law, whether in the UK or other jurisdictions within Europe, particular majorities that apply for special resolutions, such as to change the constitution of the company, to change its name, or to liquidate it, where the normal rule of majority rule is changed. And so a minority will have a certain amount of protection in that respect. Minority protection rights, though, are usually negotiated in addition to what is implied by the law, and you will often have a series of particular consent rights that apply in a joint venture, so that the minority parties have equal voting rights on particular issues as they come up. When thinking about your funding and how to get the cash back in a contractual joint venture, because the two parties remain separate, simply parties to the contract will determine how the cash arising from the joint venture is returned to the parties. Again, you have the same risk if there's a gap in the contract, if the contract does not anticipate every way in which cash can be returned, then there is potentially a problem. And I'll say a little bit about that towards the end of the presentation. In a partnership, this is a different environment. One of the advantages of a partnership is there's no minimum capital requirement. Sometimes in different jurisdictions in Europe, a minimum amount of capital is required in order to start a corporate joint venture, whereas no such rules apply for a partnership. You can start a partnership with simply €2, and there are no minimum capital rules that apply, no insolvency rules that apply. And that's very convenient. It means that you can move cash around within the partnership simply as the partners agree. So returning cash and the extent of the funding is dependent upon the agreement between the parties. One partner cannot oblige another partner to contribute new cash, so partnership agreements do have to make provision for funding, but at least the return of cash, the formalities associated with that, are very simple. In a corporate joint venture, the funding of the joint venture is usually quite formal. You will have your share capital, which is fixed and can only be returned if you have a formal reduction of capital or a liquidation of the company. And because of the inflexibility of fixed capital, parties to a joint venture will often agree particular funding arrangements, whether they are loan contracts, which are obviously repayable on their terms, and the interest provides a return on capital, or other ancillary agreements such as management contracts or the licenses of intellectual property against which a royalty is paid, or other supply agreements that may be entered into. So the contractual joint venture, the picture that's emerging here is that this is an efficient way to manage risk, but it brings particular challenges for management and control. The documentation needs to be carefully drafted to ensure that there is a good balance between the parties on management and control. And on the funding and return of cash, again, specific regulations, specific arrangements should be entered into in order to ensure that cash is not locked up and, subject to insolvency rules, cannot be extracted from the joint venture company.